going to the school, but didn't know what basis he had for getting him out of there. But in the conversation, he said to him, you know, it's not just you, it's affecting our whole family. You know, the judge said some really bad things about your mother. He said she's a bad mom because she let you get into trouble. Well, that outraged Gerald, and now he wants to fight it. And he told his father, you do whatever you have to do to set the record straight. And that's a typical child reaction. They believe very strongly in fairness in this process. Not just for them, but for the people around him. And his love for his mother and his belief that his mother was a good mother is what made the Gault case come forward. Okay? So attorneys are very important in this process. In criminal proceedings, counsel is appointed at every critical stage of the proceeding. And you can certainly make a strong argument that every stage of the interaction between children and the legal system is a critical stage, from questioning by the police through post-dispositional and appeal. But I argue that as child advocates, as child lawyers, we have an ethical obligation to go even further than that. And we might want to say that as child lawyers, we have to take a preventative role. And this is where our pro bono activities, and our ethical obligations should come into play, and we should be involved with children before they're even involved with the system. Lawyers can interact with children through the schools, through religious organizations, through community groups, provide mentoring, role modeling, leadership. Most attorneys would say that they represent the child and information to children so that if they do get into trouble, it helps them better understand the system, their rights, and their responsibilities. And this is just one of the ways that I think we did not take Gault far enough. We let the courts, we let a typical criminal model talk about how we're going to interact with our child clients. In criminal matters, you're clear about who your client is. It's the defendant. It's the person sitting next to you, the adult. They make the decisions. They help you frame the case. With a child, it's not always so clear. Attorneys are also often very conflicted. Are they representing the child? Are they representing the parent, the family, the community, or themselves in that process? Most attorneys would say that they represent the child, but it's not always the way that we act. And oftentimes, you'll be at a hearing, particularly detention hearings, you'll have a child that you're supposed to be arguing for release because that's what your client wants. And how often do we turn to the parent and say to the parent, what do you want? What do you want the judge to do? Oh, you feel conflicted? You're not sure that you can have this child home? Well, Judge, Your Honor, you see, we can't send this child home yet. That's not advocating for your client, the child. It's also very difficult to just represent the child if you know that the parent's footing the bill. And so we often forget to explain to parents very carefully that the child is our client. What we say to them is between us and them, and not to be released to the parent without the child's consent. Parents have a problem with that, lawyers have a problem with that, and oftentimes judges have a problem with that. So sometimes, in many jurisdictions, attorneys find themselves even being appointed to represent both the child and the parent. It's also important for the lawyer to make sure that they take the time with their client, the child, so that they can counsel them and help them make the decisions that will be most important for them and will actually meet both their wishes and hopefully what will be best for the child at the same time. But none of this is easy to do because as adults we often want to enter into a protective mode, acting on what we believe is best rather than what the child wants. Another area of concern is how we determine indigency. With adult clients, somebody, the court officer, the probation officer, the judge, determines the client's not so clear of a process. With children, the states consider the parents' resources rather than the child's, and they take one of two approaches usually. Either they'll do an assessment in the very beginning of the proceedings, and if the parent is not indigent, not appoint counsel for the child. In some jurisdictions, they'll appoint counsel, do the assessment of indigency later, and charge the parent for the services. This does not make sure that a child is going to get counsel. It's going to put a lot of pressure on the child to waive counsel. It's going to put the parent in the position of joining that waiver. And when the court forces the parent to pay for attorney fees, it's already adding additional tension to a very stressful family situation. The only approach that really will protect the child's interest and make sure that they do have counsel representing them is to determine it based on the child's income, and to make sure that it's based only on that income that's accessible to the child. So even if you have a child that's earning some money, but it's in a trust fund, they would still be indigent and entitled to representation. It's also important to make sure that we examine waiver. And this is an area where I think children, attorneys, appellate attorneys will all come out at different places for different reasons. But one of the problems with allowing waiver for children, although many people have it, because if you're giving the child the constitutional right of an attorney, you should also give them the constitutional right to waiver. Right? It makes sense. But on the other hand, children are much less likely to understand the consequences that come along with waiving counsel. They will have much more difficulty dealing with the delinquency hearing on their own. They're much more susceptible to pressure by the adults involved in the process. The judge may encourage the child to waive counsel so that he can keep the docket moving. The probation officer may encourage the child to waive counsel because they believe if the child didn't do anything, the system will work, they'll get off, it won't matter, counsel isn't necessary. Or it doesn't really matter whether the child did the act or not, because this child needs help and an attorney will just get in the way. The parent will put pressure on the child to waive counsel because they don't want to pay for it. They're embarrassed. They just want to get through the system as quickly as possible, and they want to encourage their child to tell the truth. So we always tell our children to tell the truth. That's the most important thing that they can do. All of this means that a child cannot make the waiver of counsel the same way that an adult can, and that even judges, when they make the inquiry into the waiver, often cannot determine that it's actually been done knowing and intelligently. At this conference that I was at a couple of weeks ago, an appellate attorney from Ohio was talking about a case that her office had won, and they were very proud because it involved the waiver of counsel. And although the court recognized that the waiver was done improperly, they also upheld the right of the child to have the right to waiver. And she felt that this was very important because the Constitution protects children just like it does adults. And the court upheld Gault. And she looked at Gerald Gault and she was saying this in jokes. No, 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 no. And I talked to him afterwards and he said, children should never be able to waive counsel. They don't understand that they need a lawyer, and waiving counsel is the worst thing that can happen to them. So when do we stop listening to children? When they're adults and they've been through the system and they know what a child needs, or should we keep listening to them through the whole process? There is a lot more that I had to say. Obviously, you all do and did, but I saw my time. So I'm going to say, just my closing, that Gault itself provided us with the opportunity to develop a very strong and meaningful system of representation for children. We missed the boat on that. We need to take charge now to make sure that representation for children is